Hello, everybody. Welcome. Today, I want to talk about another F1 student that had their SEVIS record terminated. And this student fought back in federal court, and they had got a settlement where the SEVIS record was reactivated. I mean, it looks like these days for immigration cases, you really have to go to federal court and fight it out with the federal government. I mean, especially with the revocation of universal injunctions, you either have to do a class action or have to file individual cases in federal court. To dive into this case, so we have this plaintiff, and then they usually name all these defendants. So plaintiff is an international student from China and have a F1 student visa, and in April 2025. Their student visa status was abruptly and unlawfully terminated by the defendant. So they just randomly just terminated the status, and he never violated the U.S. immigration laws and has been working in the U.S. As part of the F1 employment authorization as part of OPT, optical practical training. The employment authorization is authorized for foreign students who have successfully graduated from their course of study, and is in fact the reason that many of these foreign students attend the U.S. colleges or universities. Plaintiff is one of almost 1,500 F1 students who had their F1 status abruptly and unlawfully terminated. I mean, so each of those 1,500, you're going to have to file individual lawsuits in federal court, if you have a reason saying, they shouldn't have done that. We're going to look at this case to see why they did it. But the termination was effectively deprived them of their ability to maintain F1 status in the U.S., and then they terminated their employment authorization, and then subjected them to, once you don't have status, you're going to be in removal proceedings, potentially detention, and possible deportation. And then all these termination notices cited unspecified criminal record check. I mean, these people didn't have any conviction. The last case we looked at, that person had was speeding, and that immigrant was arrested for speeding. But again, I question that. A lot of people speed, and I know most people just get a ticket, they're not arrested. But when you're an immigrant, who knows what can happen to you. And then they're saying that almost none of the students had a disqualifying criminal record, and this case is no different because they don't seem to have a criminal record. I will go into what happened, but plaintiff only criminal incident was an arrest in Boston in December 2021, which did not result in any conviction. I mean, just because somebody's arrested, I mean, you're innocent until proven guilty, right? So in fact, it did not even result in formal charges. That matter was dismissed on motion, and then they're saying this arrest is not a basis for to terminate F1 status, and did not make him deportable or removed from the U.S. And nonetheless, the government terminated the F1 status based on that. So as a result of the termination, which he didn't have any prior notice of that, or any opportunity to contest the termination. He's now subject to being placed on removal proceedings, detained and deported, and his employment authorization is terminated. Can no longer work. He can no longer pursue a career that he wants, and he may lose his eligibility for long-term employment in his field. And then they're bringing this action under the Fifth Amendment regarding due process and Administrative Procedure Act, and they're saying this court has jurisdiction. And this is the right venue for a number of reasons. They're saying that this action took place in New Jersey, and the defendants have offices in that area. So the parties are, like I mentioned, is a citizen of China, and then they list a couple of defendants as usual. So the relevant law they're talking about, U.S. immigration allows certain F1 is a non-immigrant visa, right? So non-citizens who enter the U.S. and attend government-approved colleges and universities on an F1 student visa. In order to be eligible for the F1, the student have to be accepted into the approved school. The acceptance is by Form I-120, which the school issues to the student. And then once they're accepted, The student applies for a visa from a U.S. consulate abroad by filing Form DS-160 with the State Department and attending an interview. And then once they're in, they remain in the U.S. for the duration of the status. And then the F1 student may be eligible for employment authorization under certain specified circumstances. They have eligible for 1 year employment authorization in the field of study. So they have to be in the field of study at the conclusion of their degree. And that 1 year is known as OPT, or optical practical training, OPT. So there's also STEM OPT, student in STEM, like science, technology, engineering, mathematics, is eligible for 2 years of called STEM OPT. So total of one plus two, so 3 years after the conclusion of the degree. And then the DHS has created something called SEVP, so the Student Exchange Visitor Program, to maintain and collect data regarding the non-immigrant students, and then goes into a web-based system called SEVIS. And they're saying for the F1 applicant, SEVIS record is a definite record of student or exchange or visa status and visa eligibility. So if your status is revoked in SEVIS, I mean, you are now you're out of status. The regulation set forth in the specific conduct by a non-immigrant will constitute a failure to maintain. So there's different ways that you can lose status by engaging in unauthorized employment, providing false information to DHS, or engaging in criminal activity. So the definition, I think it's important to look at how the definition of criminal activity is defined. So criminal activity is defined any conviction for a crime of violence for which a sentence of more than 1 year imprisonment may be imposed. So it says, there has to be a conviction. So somebody that was arrested, that's not a conviction. So that doesn't follow the laws and regulations. So non-immigrant has failed to maintain their non-immigrant status, is deportable. And then in the absence of F1 students' conduct causing a status violation, ICE may only terminate SEVIS record there's a couple other circumstances they can terminate, and then there's no administrative appeal. So the statement of facts is that, like we mentioned, a plaintiff returned to the U.S. for a master's degree in information science from Boston University. He's graduated, has issued a 1 year OPT, and then extended for additional 2 years because I guess he's part of the STEM OPT. So here's what happened with that criminal case. I guess plaintiff was involved in an altercation with his landlord in Boston, where the landlord assaulted him. So it looks like the landlord assaulted him, or at least that's what his complaint is alleging. And the police were called and arrested the plaintiff instead of his landlord. I mean, when you look at these cases with immigrants, like, immigrant who has an accent or who looks differently than the landlord and, can't really, speak with an American accent, and then suddenly, the police is taking the side of the landlord, and the landlord, and they're arresting the plaintiff instead of the landlord. Okay, that's besides the point, but he was never arraigned, and no complaint or indictment was ever filed. After 2 court appearances, the Commonwealth, so the prosecutor there moved to dismiss the case. So the case was dismissed. And I remember we talked about the definition for criminal, right? So which is basically that you have to have a conviction. So other than this, he was never arrested, had any contact with the criminal justice system. So then it's saying that April, he received an email from the school telling him that his SEVIS record was terminated. And upon review of his SEVIS portal, he noticed that it said terminated for otherwise failing to maintain status. And then it says in the last 2 weeks, DHS has similarly revoked the status of almost 1,500 foreign students. And, you wonder, like, how many of them are in that similar situation where there's no conviction, without notice, you can't contest it. And instead, the student received a notification from the school that the student's SEVIS status has been terminated because of criminal history check or visa revocation. In many of these cases, an actual criminal history check reveals those criminal charges were dismissed as they were in this case, thus are not a basis for status violation. Okay, so they're claiming that the violation of the Due Process Clause and a couple of the Administrative Procedure Act, in terms of, contrary to constitutional right, and then not in accordance with the law, and arbitrary and capricious agency action. And then what they were requesting in the complaint is to grant the court to take jurisdiction over the matter, declare that the defendant's termination of the plaintiff F1 status violated his due process rights, and then reinstate the SEVIS, and then reinstate his F1 status, and issue an injunction requiring defendants to provide an individualized hearing before an impartial adjudicator, enjoin defendants from detaining plaintiff during the pendency of the case, and then award attorney's fees. I do want to show you, if you do fight back sometimes, I do want to show you the settlement agreement that they had reached. So here's a settlement. So here's a stipulation where they are going to reactivate the SEVIS record and a dismissal. So they're saying it is hereby stipulated by and between the parties, which is pretty much a settlement, that the student and exchange visitor information SEVIS has been set back to active. I mean, imagine that you don't have the money to hire this lawyer, or you don't know how to fight back. I mean, you're you're pretty much out of luck. I mean, if you with immigration, looks like more and more you're going to have to fight back in federal court. The reactivation of the plaintiff's SEVIS record is retroactive to the date of his initial termination, such that there's no gap or lapse in plaintiff's SEVIS, and then it is retroactive to the termination of. It is retroactive as though it didn't happen. So why did they do this to him in the first place? Like, he has to spend money on these lawyers and put the it's back to reactivation, retroactive, as though it never happened, and they're going to provide a letter and to the council explain that other federal agents should treat the retroactive activation as though the termination did not happen. And it says, ICE will not re-terminate his SEVIS record based solely on, I guess they got the information from something called National Crime and NCIC, National Crime and Information Center. And it says ICE maintains authority to terminate the SEVIS record on other reasons, such as if a student fails to maintain their non-immigrant status after the record is reactivated or engage in other unlawful activity. If you like this, give me a thumbs up, like, subscribe. Thank you very much.